My simple answer to this in one word will be no. The RERA Act, if read in its entirety, provides ample clarity on this. First and the foremost, it has to be remembered that a complaint is filed with a RERA authority against the promoter and not the real estate project. Section 31 of the Act make it crystal clear. Let's start from the preamble of the Act to understand whether the Act bars complaint against the unregistered project. Preamble says an act to establish real estate regulatory authority for regulation and promotion of real estate sector and to ensure sale of plots, apartment or building as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect the interest of consumer in the real estate sector. Now it says real estate project and not registered real estate project. Also, RERA authority will protect the interest of consumer in the real estate sector, which again will have registered as well as unregistered project. Now let's take section wise interpretation. Section 2ZN defines real estate project. The definition never says that real estate project means only registered real estate project. Therefore, it can be interpreted that it includes both registered as well as unregistered projects. Again, proviso to section 12 provides that if the person affected by the incorrect, false statement in the advertisement or the prospectus issued by the promoter to withdraw from the proposed project, he shall be returned his entire investment along with interest. Now it says proposed project, which is definitely different from registered one. And where will such person go for the refund or for the compensation? It has to be RERA authority. Therefore, again, it can be said that RERA authority can hear complaint not only against unregistered project but also one step ahead, that is against the project which are proposed. Section 18 talks about the refund of the amount and the compensation in case of delay in possession of the apartment, flat or a plot. It says allottee can withdraw from the project and not necessary registered real estate project if the promoter fails to deliver the project agreed between the promoter and the allottee. After the sections, now let's see some of the order or judgments passed by RERA authority, RERA tribunals and high courts on the subject unregistered issue. In the Mohammed Zain Khan versus Maharashtra Real Estate Regulatory Authority, MahaRERA, Bombay High Court held that the complaint tendered online by the petitioner and other similar situated complaints in respect of unregistered project would be entertained and the same would be dealt with accordance with the procedure that is being adopted by MahaRERA in respect of disposal of the complaint in relation to registered projects. So the RERA authority will give same treatment and there would be no difference between registered and unregistered project. In case of Messrs. Silver Steel Construction Limited versus State of Punjab, the Real Estate Appellate Tribunal Punjab held that not a single provision of the Act 2016 makes out any such classification or distinction about the project which are registered or not registered, or the promoters whose projects are registered or not registered. This is true as we saw few seconds ago. Also, in other words, a promoter who doesn't decide to register his project at all would enjoy all the premium of breaking the law, and a promoter who registers his project with the RERA authority will have to abide by the rule of law of the Act 2016, also its rules. Such an absurd or bizarre interpretation cannot be made, which would defeat the very purpose, policy, and the object of RERA Act. Again, in Jitendra Kumar Jina versus Messrs DLF Limited, the Odisha Real Estate Regulatory Authority, Bhubaneswar, held that Section 61, which is for the penalty for contravention of any provision of RERA Act, it does not differentiate between a registered real estate project or an unregistered real estate project, or even exempted project, or the project deliberately left unregistered. If the contention is accepted that the RERA has no jurisdiction to entertain a complaint in respect of unregistered project, then it would not only afford incentive to the contravenor, that is the promoter, to escape the law, but would also defeat the object and the purpose for which the act was enacted, which would not be the intention of the legislature, that is the RERA Act. And the same was also held in Mrs. Simi Sikka versus MRMGF Land Limited by the Haryana Real Estate Regulatory Authority, Gurugram. Section 3 of RERA makes it mandatory for the developer to register their real estate project with the RERA authority before a promoter can even advertise or sell the plot, apartment, or the building. And if the promoter fails to register, then heavy penalty up to 10% of the estimated cost of the real estate project can be levied on the promoter, which would be huge cost on the promoter. When the promoter registered the real estate project with the state RERA authority, the promoter uploads lot of information about the project on the state RERA website where the real estate project is located, like registered address of the promoter, details of the co-promoter, and the details of agreement between them, past and ongoing project, their completion date, number of total flats in a project, out of which how many have been sold and how many are unsold, project and the amenities, construction status, number of ongoing legal cases, layouts, copy of approvals, and various other information. All this information help the allottee, to make an informed decision about investing or purchasing an apartment in the real estate project. Before RERA, an allottee had no source to get all this information before investing or purchasing a flat or apartment. But now he can, by not just going by through RERA website, can get all the information. In this way, registration of real estate project is very important, specifically for transparency purpose. First of all, when an allottee purchase the under construction or ongoing project, it should be a registered project with the state RERA authority and should have a RERA number allotted. Even before visiting the site of the real estate project, the prospective allottee, that is the prospective allottee, should check the details of the project so that he or she can ask more relevant questions about the project when they visit the site. There is also a misconception that since the project is registered with RERA authority, it is safe to invest or buy the flats or the apartment. It should be remembered that just because a project is registered with the RERA authority, it doesn't mean the RERA authority is overlooking the construction of the real estate project or its quality or its timeline, and the most important, It is a RERA registered project and not RERA approved project. There is a difference. RERA authority registers the project when a prescribed information of the real estate project is submitted by the promoter and prima facie it is okay. The allottee should always remember that registration is an assurance and not a guarantee that an allottee will get his or her flat on time and with all the amenities as agreed between them.